Welcome to LexTalks, Legal Topics Simplified, where we break down complex legal concepts, making them easy to digest. Today, we're diving deep into a topic that's a cornerstone of legal practice, especially here in India. Awards.
Awards.
Yes, awards. We'll be exploring what they are, the different types, and the potential hurdles in enforcing them, particularly those tricky foreign awards.
I see. It's interesting how the word award takes on a whole new meaning in law. We're not talking about accolades or trophies.
Definitely not. So, what exactly is an award in the legal sense?
In simple terms, it's a decision made by a panel of arbitrators to settle a dispute. Think of it as a mini court outside the usual court system.
A mini court. Interesting. So instead of judges, we have arbitrators making the call.
Exactly. And the key here is that both parties involved agree to use arbitration beforehand. They're essentially choosing to bypass the traditional court system and let this panel decide.
Makes sense. So it's like choosing a referee before a game. But what makes their decision, the award, so important?
Well, the award is legally binding. It carries the same weight as a court order.
Okay, so it's a serious decision with real consequences. But how does this whole arbitration process actually work?
It resembles a court trial in many ways. Both sides present their arguments, evidence, and witnesses. The panel then weighs the evidence, deliberates, and issues a written decision.
Right, so that written decision is the award. And what does it typically contain?
The award outlines the solution to the dispute. It might include things like financial compensation or specific actions that one or both parties need to take.
Okay, I'm starting to get the picture.
Hmm.
But you mentioned foreign awards earlier. What makes them stand out, and why are they considered tricky?
Imagine you have a legal document from another country. You can't just assume it automatically has the same power in India, right?
Right.
Foreign awards are similar. They originate outside India's legal system. So enforcing them here requires a different set of rules and procedures.
I see. So it's like needing to translate a document before an Indian court can even consider it.
That's a good analogy. And for foreign awards, India relies on two main translation guides, the New York Convention and the Geneva Convention. These are international agreements aimed at making cross-border enforcement smoother.
Okay, two separate conventions. Let's start with the New York Convention. What makes it so important in this context?
Think of it like a passport that allows entry into a country. But there are conditions.
Entry requirements.
Exactly. The New York Convention makes it easier to enforce awards in different countries. But to be recognized in India under this convention, the country where the award was made must also be a signatory.
Oh, so it's not automatic. Anything else?
Crucially, the award must be about a matter considered commercial under Indian law.
So it's not a free pass. The award needs to meet specific criteria to be allowed into the Indian legal system. What about the Geneva Convention? How does that differ?
The Geneva Convention is more specialized. It focuses on awards related to commercial matters, but only those that originated after July 28, 1924. And it's even more particular about the countries involved.
Even more specific.
Yes, there's a specific agreement, the Geneva Protocol on Arbitration Clauses, that needs to be in place before the arbitration even begins.
So, two different pathways for foreign awards to be recognized, each with its own set of rules. But even if an award meets all the criteria, is it smooth sailing from there?
Not exactly. Enforcing a foreign award in India isn't automatic. You need to follow the right procedures and present the correct documents to an Indian court.
Okay, so it's like having all the right ingredients but still needing to follow the recipe carefully. What kind of documents are we talking about?
You'd need the original award, or a certified copy, then proof that the award is final and binding in the country it came from, and of course evidence that the initial agreement to arbitrate was valid in the first place.
Got it. A lot of paperwork involved. So what happens if you don't have everything in order?
The Indian court might just refuse to enforce the award.
Now, this is where it gets really interesting for us law students. So what are some reasons an Indian court might actually reject a foreign award, even if it's made under one of these conventions?
Well, that's where Section 48 of the Indian Arbitration and Conciliation Act of 1996 comes into play. This section outlines the grounds under which a foreign award can be refused enforcement.
Section 48, got it. So what are some of the red flags that could lead to a foreign award being rejected?
One of the first things the court looks at is the capacity of the parties involved. Basically, were they legally capable of entering into the agreement that led to the arbitration in the first place?
So like checking the validity of a contract.
Precisely. For instance, if one of the parties was a minor or lacked the mental capacity to understand the agreement, the whole award could be thrown out.
Makes sense. So the foundation needs to be solid. What else do the courts scrutinize?
Another crucial aspect is the validity of the arbitration agreement itself. Was it obtained fairly? Was it clear about what issues were being arbitrated? If there are flaws in the agreement, the award built upon it won't stand.
So any hint of coercion or ambiguity could be a problem. What else could lead to rejection?
A fundamental principle is that all parties must be given proper notice of the arbitration proceedings. If a party wasn't properly informed or couldn't present their case, that's grounds for refusal.
So everyone deserves a fair hearing no matter what.
Absolutely. Fairness is key here. The court also checks whether the award stayed within the boundaries of what the parties agreed to arbitrate. We call this the scope of the arbitration.
The scope, okay. So the arbitrators can't just go off on a tangent and decide things that weren't part of the original agreement.
Exactly. There needs to be a clear link between the issues in the award and what the parties initially agreed to arbitrate.
It's all about sticking to the plan. Are there any other checks and balances in this process?
The Indian courts also examine the arbitration process itself, to make sure everything was above board.
So was the process unbiased and transparent? Did both sides have a genuine opportunity to present their case?
Precisely. If the process itself was flawed, the court might question the validity of the award, even if the outcome seems fair.
It's like making sure the game was played fairly, regardless of who won or lost. What other factors come into play?
Well, there's also the question of whether the award is actually binding on the parties. It's not enough for the arbitrators to just issue a decision, you see.
So there are additional steps to make it official?
Yes. Usually there are procedures to make an award final and enforceable. Until those are followed, the award can be challenged.
So even if the decision is made, there's a process to make it officially locked in.
Right.
Are there any other deal breakers that we haven't covered?
Absolutely. One crucial factor is whether the dispute can even be settled through arbitration in India. Some issues, like criminal offenses or family matters, are strictly off limits.
Oh, I see. So some topics are a no-go, regardless of where the award comes from. Makes sense. What else?
And finally, there's one last hurdle, arguably the most crucial: public policy.
Public policy. That sounds like a big one.
It is. Even if a foreign award ticks all the boxes we've discussed, it can still be refused if it goes against India's core values and principles.
So it's a safeguard to ensure that foreign awards don't undermine India's legal and moral framework.
Exactly. For example, an award that contradicts a core principle of Indian law, like promoting discrimination, would clearly violate public policy.
So public policy acts as a final check, ensuring the foreign award aligns with India's fundamental principles.
Precisely.
Okay, we've covered a lot of ground here, from the basic definition of an award to the intricacies of enforcing those tricky foreign ones. But have there been any real-life cases that highlight how this public policy exception actually works in practice?
Well, absolutely. There have been several landmark cases where public policy played a crucial role. One such case, the White Industries case, is a perfect example of the complexities and potential pitfalls of this exception.
The White Industries case. Okay, tell me more. Why is it so significant?
In this case, an Australian company, White Industries, won a significant sum in an arbitration against Coal India Limited, an Indian public sector company. But when they tried to enforce this award in India, things got complicated.
So typical delays in the Indian legal system.
Well, yes, in a sense, but what made this case unique was that Australia, on behalf of White Industries, took a bold step. They sued India in an international tribunal.
Wow, they sued India. That's a big deal. And what was their reasoning?
They argued that the excessive delays in the Indian courts violated India's obligations to treat foreign investors fairly under a bilateral investment treaty.
So taking things to a whole new level.
Oh.
And what was the outcome of this international tribunal?
The tribunal actually ruled in favor of Australia. They criticized India for its handling of the case. This decision sent shockwaves through the Indian legal community.
It sounds like a major wake-up call for India. Did it lead to any changes in how India handles foreign awards?
Absolutely. The White Industries case, along with growing criticism from the international community, pushed India to take a hard look at its arbitration laws. This led to some significant amendments in 2015.
So a catalyst for reform. Can you tell us more about these 2015 amendments and how they changed the landscape for foreign awards in India?
These amendments aim to streamline the enforcement process, reduce delays, and clarify the grounds for refusal, especially that public policy exception.
So India decided to modernize its approach, making things clearer and more in line with international standards. What were some of the specific changes introduced?
One key change was narrowing down the grounds for refusing foreign awards under Section 48. The idea was to limit the circumstances in which courts could reject an award. They also tried to provide a clearer definition of public policy to prevent inconsistent interpretations.
So less room for arbitrary decisions. Sounds like a positive step towards making India a more attractive place for international business.
Exactly. The 2015 amendments were a big step forward, demonstrating India's commitment to creating a more robust and reliable system for resolving international commercial disputes.
It sounds like India is serious about attracting foreign investment and becoming a key player in international arbitration.
Absolutely.
Well, that's quite a bit to digest. We've covered everything from the basic definition of an award to the complexities of enforcing them, especially those from overseas. But before we wrap up this part of our deep dive, are there any key takeaways you want our listeners to remember about this complex topic?
One crucial point is understanding the difference between domestic and foreign awards. They operate under different rules, and navigating these differences is essential for any aspiring lawyer.
It's like speaking two different legal languages.
Yes. Another takeaway is that enforcing a foreign award in India is a meticulous process. You need to understand the relevant conventions and prepare your documentation thoroughly.
It sounds like a legal marathon, requiring careful preparation and a deep understanding of the rules.
That's a great way to put it. And remember, as India continues to grow on the global stage, we can expect even more changes and developments in its arbitration laws.
It's definitely a field to watch.
Absolutely.
Well, I think we've given our listeners a lot to think about today. But before we move on, is there a final thought-provoking question or challenge you'd like to leave them with? Something to ponder as we move into the next part of our deep dive.
Here's a thought. We've talked about the challenges of enforcing foreign awards. But what about the other side of the coin? What are the advantages of choosing arbitration, particularly in international disputes?
Interesting. So shifting the focus from challenges to benefits, why would someone opt for this route?
Precisely. And how can understanding the nuances of awards help people make informed decisions about resolving their disagreements effectively?
Excellent questions. It encourages us to think beyond the hurdles and consider the strategic advantages of arbitration. We'll definitely delve deeper into those aspects in our next segment.
We'll also look at some fascinating case studies that illustrate the practical application of these principles.
Sounds intriguing. Stay tuned, law students, as we continue to explore the world of awards in India.
Welcome back to LexTalks. Before we jump into those case studies, I think it's worth taking a closer look at the different categories of awards. We've discussed domestic and foreign awards, but there are interesting distinctions even within those broad categories.
Okay, so let's unpack those subcategories a bit. What other variations should we be aware of?
Let's start with domestic awards. One type you'll come across is the interim award. This is a decision made by the arbitral tribunal during the proceedings, before the final award is issued.
So it's like a preliminary ruling, addressing specific issues that need immediate attention.
Exactly. Imagine a construction project that's stalled because of a dispute over the quality of materials. Waiting for the final award could cause huge delays and cost overruns.
Makes sense. Time is money in those situations.
Right. So in such cases, an interim award can address that specific dispute quickly, allowing the project to move forward.
That's a really practical example. It's like taking a quick detour to deal with a roadblock before continuing on the main journey. Are there any specific legal provisions in India that deal with these interim awards?
Yes, Section 17 of the Arbitration and Conciliation Act, 1996. It empowers the tribunal to grant interim measures, including these interim awards.
Section 17. Got it. Any notable case law around interim awards?
There's a landmark case, Sundaram Finance Ltd v NEPC, India Ltd. The Supreme Court upheld the enforceability of interim awards in that case. They emphasized their importance in making sure the arbitration process actually works.
So they have a solid legal basis.
Mm.
What other types of domestic awards should law students be aware of?
Another interesting category is the consent award. This is basically a settlement agreement. The parties reach it themselves, during the arbitration.
So instead of letting the arbitrators decide, the parties come to a compromise on their own.
Exactly. And they ask the tribunal to just record their agreement as a consent award.
So it's like taking control of the situation, hammering out a solution that works for everyone. What are the benefits of going this route?
Well, for one, it gives the parties more control. They can tailor the solution to their specific needs and interests. It also encourages collaboration, which can be good for maintaining those business relationships.
Less adversarial, more about finding common ground.
Exactly. And of course, it can save time and money by avoiding a full-blown hearing.
Consent awards sound like a win-win. It's like avoiding a long, drawn-out court battle by settling out of court. Are there any specific legal provisions that deal with consent awards in India?
Yes, Section 30 of the Arbitration and Conciliation Act. It deals with the power of the tribunal to record such a settlement. So basically, if the parties agree, the tribunal can end the arbitration and record the settlement as an award.
So it's formally recognized under Indian law. Does it have the same legal force as other awards?
Absolutely, it becomes binding, just like any other arbitral award.
Okay, good to know. Is there any case that illustrates how these consent awards work in practice?
A notable case is National Insurance Co., Ltd v. Bogara Polyfab PVT Ltd. In this case, one party later challenged the consent award, but the court upheld it. They emphasized that settlements reached during arbitration should be honored.
So courts respect that principle of party autonomy. What other types of domestic awards are there?
One more to mention, the additional award. This one comes after the final award.
After. What's the purpose of that?
It's typically used to address things that were missed in the initial award or need further clarification.
So it's like a supplement,
Yeah,
tying up any loose ends.
you got it.
Are there provisions for this in the Act as well?
Yes, Section 33 deals with additional awards. It allows a party to request one within 30 days of getting the final award. Of course, they need to explain why they're asking for it, and the tribunal decides whether to grant it or not.
So it acts as a safety net, making sure nothing important gets overlooked. Any cases that highlight how this works in practice?
One relevant case is Steel Authority of India Ltd v. Gupta Brothers Steel Tubes Ltd. In this case, the tribunal had forgotten to address the interest on the awarded amount. One party requested an additional award to fix this, and the court agreed they could do that.
Okay, so these additional awards fill in any gaps or omissions in the final judgment. We've covered domestic awards pretty thoroughly now. Let's shift back to those foreign awards. Are there any notable distinctions within that category that we should be aware of?
Well, foreign awards don't really have formal subcategories like domestic ones, but it's important to know which convention a particular award falls under.
Right, the New York Convention versus the Geneva Convention. We talked about that earlier.
Exactly. The rules and procedures for enforcement can be quite different depending on which convention applies.
It's like knowing which legal dictionary to use. Different conventions, different rules of the game.
That's a good analogy. Another distinction is the type of dispute involved. Some foreign awards might be about simple commercial matters, like a breach of contract, while others might deal with more complex issues, like investment treaty disputes or intellectual property violations.
So the complexity of the case can impact how it's enforced in India.
Definitely.
What are some of the challenges that come up when dealing with foreign awards that involve these more complex legal questions?
One challenge is that different countries have different legal traditions. Sometimes a foreign award might be based on legal principles that are quite different from Indian law. This can create problems during enforcement.
So it's like trying to merge two different legal systems.
Exactly.
What strategies do lawyers use to overcome these challenges?
Well, one common strategy is to focus on the similarities. They try to highlight how the foreign legal principles are actually compatible with Indian law, even if they look different at first glance.
So it's about building bridges, finding common ground.
Yes. And they might also cite international precedents and expert opinions to support their arguments. It's all about persuading the Indian courts that enforcing the award wouldn't go against India's basic sense of justice.
It's about showing that the foreign award, even with its different origins, is still in line with India's core values.
Exactly.
This brings us back to that crucial concept of public policy. How do courts decide whether a foreign award actually violates Indian public policy, especially when dealing with these complex legal issues?
That's one of the trickiest parts of foreign award enforcement. Courts have to really dig deep, They look at the award itself, the legal principles involved, and how enforcing it would impact India's public interest. They have to ask themselves, would upholding this award contradict any of India's fundamental values or laws?
It's a weighty decision, I'm sure.
It is.
Are there any cases that illustrate how courts have approached this public policy question in these more complex scenarios?
One notable case is Sri La Mahal Ltd v. Progetto Grano Spa, decided by the Supreme Court. This case involved a foreign award related to a joint venture agreement. The award was based on Italian law, which had some key differences from Indian law.
So a classic clash of legal systems. How did the Supreme Court handle the public policy question in this case?
The court took a really thorough approach. They analyzed the award, the relevant Indian laws, and acknowledged the differences. But ultimately, they decided that enforcing this particular award wouldn't go against any fundamental principles of Indian public policy.
So differences in legal systems don't automatically mean a violation of public policy. They really focused on the substance of the award and whether it conflicted with India's core values. What were the key factors that swayed the court's decision?
They emphasized that public policy isn't set in stone, it has to evolve with the times. They also highlighted the importance of respecting international agreements and promoting arbitration in India.
So they took a balanced approach, weighing India's interests with the need to support international commerce and dispute resolution. It sounds like the Sri Lal Mahal case provides a good example of how courts navigate this tricky public policy issue, especially when dealing with awards from different legal systems.
It does. It shows that courts are willing to look at the specifics of each case, balancing domestic laws with international norms.
It's all about finding that balance.
Right.
Are there any other points about the public policy exception that we should keep in mind when it comes to these foreign awards?
Yes. One thing to remember is that how courts interpret and apply public policy is constantly changing. Court decisions, new laws, changing societal values. It's a dynamic area.
So it's not a static concept. Lawyers need to keep their fingers on the pulse of legal developments.
Exactly.
Well, I think we've covered a lot of ground in this segment. Different types of awards, challenges of enforcement, and that crucial role of public policy. But before we wrap up and move on to our case studies, is there any takeaway message or question you want to leave our listeners with? Something to really make them think about the future of arbitration and awards in India.
Here's something to ponder. We've focused on the legal frameworks and procedures, but how do you think things like globalization and technology are impacting arbitration? How can India become a global leader in this field, attracting businesses and investors looking for efficient ways to resolve disputes?
Excellent questions. It encourages us to look beyond the current legal landscape and think about the bigger picture. How is the world of arbitration evolving, and where does India fit in?
Precisely. In our next segment, we'll explore some real-world cases that put these principles into action. We'll also discuss how India is adapting its arbitration system to keep pace with these changes.
Sounds fascinating. Stay tuned, everyone. Welcome back to LexTalks. Over the last two segments, we've really dug deep into the world of awards, domestic, foreign, all the complexities. But now it's time to bring it all to life with some real-world examples, don't you think?
Absolutely. Case studies are a fantastic way to see how these abstract legal concepts actually play out in real disputes.
It's like watching a legal drama unfold, but with real-world consequences.
Exactly.
So do you have a case that really highlights the challenges of enforcing those foreign awards in India?
There's one that comes to mind, Fulton Exports Ltd v. OO Patriot, decided by the Bombay High Court back in 2011.
Okay, Fulton Exports, what happened there?
It involved an Indian company, Fulton Exports, and a Russian company, OO Patriot. They had a dispute over a contract for steel coils.
Steel coils, okay.
Yeah.
And where did the arbitration take place?
In London, actually. Under the rules of the London Metal Exchange, Fulton Exports ended up winning the case and got a favorable award.
So a classic cross-border commercial dispute.
Yeah.
What happened when they tried to enforce that award back in India?
Well, O Patriot, the Russian company, wasn't happy with the outcome, naturally. They challenged the enforcement, claiming it violated Indian public policy.
Ah, the public policy defense. We talked about that earlier.
Right. Their argument was that the London Tribunal had awarded damages based on principles that weren't recognized under Indian contract law.
So basically, different legal systems, different approaches to calculating damages.
Precisely. And they tried to use that difference to their advantage.
Clever tactic.
Yeah.
How did the Bombay High Court respond to this argument?
The court had to consider, do differences in how damages are calculated automatically mean a foreign award violates Indian public policy? It's a tricky question.
It is. So what did they decide?
They ultimately rejected O Patriot's argument. The court emphasized that Indian courts shouldn't just toss out a foreign award simply because of variations in legal principles or how damages are calculated.
So the differences in this case weren't enough to throw out the entire award. What was the court's reasoning?
They relied on a key principle from a Supreme Court case, Renusagar Power Co., Ltd v. General Electric Co. This principle says that a foreign award can only be set aside for public policy reasons if it would shock the conscience of the court or be clearly harmful to the public good.
Shock the conscience of the court. That's a pretty high bar.
It is. So basically, there needs to be a serious conflict with fundamental notions of justice or the public interest. Mere differences in legal technicalities aren't enough.
So what's the takeaway from the Fulton Exports case for anyone dealing with foreign award enforcement?
It reinforces the idea that Indian courts are generally hesitant to overturn foreign awards based on weak or vague public policy claims. You need to show a clear and strong connection between the award and some fundamental principle of Indian law or public policy.
It's not enough to just point out differences. You need to prove a real conflict. Okay, great. Do you have another case that illustrates a different kind of challenge in enforcing foreign awards?
Let's take a look at Cruise City 1 Mauritius Holdings v. Unitech Limited, a case decided by the Delhi High Court in 2017.
Cruise City. Okay. And what was the dispute about in this one?
This one revolved around a share purchase agreement between a Mauritian investment firm and an Indian real estate company, Unitech Limited. The arbitration happened in Singapore, and the Mauritian firm won.
Another international commercial dispute resolved through arbitration. What happened when they tried to enforce it in India?
Unitech, the Indian company, fought back. They argued that they hadn't been properly notified about the arbitration proceedings in Singapore. They claimed this violated their right to a fair hearing.
Ah, so this challenge is about procedural fairness during the arbitration itself. Interesting.
Right. They said that because they weren't properly informed, the award shouldn't be enforceable in India.
So how did the Delhi High Court handle this argument?
The court really scrutinized the evidence, looking at all the communication between the parties. They wanted to determine whether Unitech had truly been left in the dark.
Due diligence, very important.
Absolutely. In the end, the court sided with the Mauritian firm. They found that Unitech had actually received sufficient notice, but chose not to participate in the arbitration.
They knew about it but chose not to engage.
Exactly. And the court made it clear that you can't deliberately skip out on the process and then later complain about not getting a fair hearing.
Makes sense. So what's the big lesson from this case about procedural fairness and enforcement?
The Cruise City case really underscores that courts generally want to uphold awards, but only if the process was fair and everyone involved had a genuine chance to present their case. If a party willingly decides to sit it out, they're less likely to get sympathy from the court.
So showing up is crucial. Don't boycott the process if you want to have a say.
Exactly.
Any other key takeaways from this case?
One important point is the critical role of documentation. In this case, the Mauritian firm was able to prove they had given proper notice because they had kept detailed records of all their communication.
So meticulous record keeping is key.
Absolutely. Maintaining thorough documentation throughout the entire process is essential, especially when it comes to proving things like serving notices. You need that clear paper trail.
It's all about dotting your I's and crossing your T's. These cases really highlight the importance of preparation, participation, and meticulous documentation in the world of international arbitration.
They do, and I think they also show that India's approach to foreign awards is evolving, becoming more aligned with global best practices.
It seems like India recognizes the need to be a welcoming place for international business and investment.
Definitely.
So before we wrap up our deep dive into awards, any final thoughts or insights you'd like to share?
Well, these cases are just a glimpse into a complex and constantly changing field. As India continues to grow on the global stage, we can expect even more developments in arbitration law and practice.
So it's an exciting area for law students to explore.
Absolutely.
Well, I think we've given our listeners a lot to think about today. We've explored the different types of awards, the challenges of enforcing them, especially those tricky foreign ones, and we've even delved into some fascinating real-world cases. It's been a real deep dive.
It has.
So, for all our law students out there, remember, the world of arbitration is dynamic and full of opportunities. Stay curious, stay informed, and never stop learning. Thanks for joining us on LexTalks, and be sure to subscribe for more legal insights.